Supreme Court Justice Amy Coney Barrett shocked the nation when she personally signed off on a sealed federal indictment against tech billionaire Elon Musk. What happened next left legal experts and political analysts completely speechless. When Musk walked into that Washington, D.C. courtroom with 3 unmarked folders, the Justice Department's strongest case in decades began to crumble in real time. The moment he presented his evidence, gasps echoed through the chamber, and Justice E.O.L. Barrett's expression changed from confidence to visible concern. If you've ever wondered what happens when unstoppable government power meets immovable tech genius, you're about to find out. Like and subscribe to see more stories of legal brilliance and unexpected courtroom twists. The courtroom camera footage captured a scene unlike any other in American judicial history. A Supreme Court justice personally presiding over a high-profile criminal case against the world's richest man. Justice Barrett sat elevated at the bench, her demeanor composed but determined. Across the room, Elon Musk appeared surprisingly relaxed for someone facing potential imprisonment, a slight smile playing at the corners of his mouth as he reviewed documents with his legal team. What no one in that packed courtroom realized was that this wasn't just a legal proceeding, it was about to become a masterclass in constitutional law and technological innovation that would redefine the relationship between government and private enterprise. Justice Amy Coney Barrett had built her career on strict constitutional interpretation and judicial restraint. Appointed to the Supreme Court after a distinguished career as a law professor and federal judge, she had earned respect across the political spectrum for her intellectual rigor and principled approach to the law. She wasn't known for seeking the spotlight, which made her unprecedented involvement in this case all the more remarkable. The case had begun 6 months earlier with a Department of Justice investigation into Musk's satellite communications network and its potential national security implication. The specific accusations involved allegations that Musk had knowingly allowed foreign governments to access sensitive communications infrastructure without proper oversight or authorization. The DOJ claimed to have evidence that Musk had personally approved these arrangements, despite direct warnings that they violated federal law. Given the constitutional significance of the case, it had been fast-tracked to the Supreme Court under a rarely invoked special jurisdiction provision. When the case was assigned to Justice Barrett, many legal observers saw it as an appropriate match given her background in constitutional and regulatory law. Elon Musk, meanwhile, had redefined what it meant to be a tech entrepreneur. After transforming the electric vehicle industry, revolutionizing space travel, and building the world's largest satellite network, he had become as much a cultural icon as a business. His unfiltered communication style and willingness to challenge established systems had earned him millions of devoted followers and powerful enemies. When the indictment was announced, Musk had responded with characteristic defiance, tweeting, "Simply the truth will prevail. Bring it on." Rather than assembling a large team of high-profile attorneys as expected, Musk had shocked the legal community by announcing he would lead his own defense with a small support team of constitutional scholars and technology experts. The stakes couldn't have been higher. If convicted, Musk faced up to 25 years in federal prison and the forced divestiture of his companies. Beyond his personal freedom, the case threatened to derail humanity's first mission to Mars, scheduled to launch within the year and potentially dismantle the global communications network his satellites had created. For Justice Barrett, the case represented an opportunity to establish clear precedent on the limits of government authority over private technology infrastructure in the national security context, an increasingly crucial question in an era of technological disruption. This case isn't about one man or one company, she had written in her decision to accept jurisdiction. It concerns fundamental questions about the constitutional balance between national security interests and private innovation, questions that will shape American technological leadership for generations. As the proceedings began that Monday morning, the tension in courtroom 2 of the Supreme Court building was palpable. Justice Department prosecutors sat confidently at their table, surrounded by boxes of evidence and flanked by national security experts. Musk's side of the courtroom appeared strikingly sparse by comparison. Just the billionaire, 2 young attorneys, and a single computer terminal. What the prosecution didn't realize was that Musk's minimal setup masked a legal strategy 18 months in the making. one that was about to turn their seemingly airtight case completely upside down. Lead prosecutor Catherine Montgomery opened with a devastatingly methodical presentation outlining the government's case against Musk. On large screens throughout the courtroom, she displayed satellite imagery, confidential communications, and technical schematics that appeared to demonstrate systematic evasion of national security protocols.
Your Honor, Montgomery stated firmly.
The evidence will show that Mr. Musk repeatedly and willfully circumvented mandatory security reviews, personally authorized transmission access to foreign entities identified as security risks, and subsequently took extraordinary measures to conceal these actions. She proceeded to present a timeline detailing specific instances when Musk had allegedly provided access to his satellite network to entities associated with foreign governments, despite explicit warnings from national security agents. This isn't about limiting innovation, she continued. This is about enforcing the law and protecting American security interests that Mr. Musk deliberately compromised for financial gain and competitive advantage. The presentation was compelling. Murmurs spread through the courtroom as particularly damning emails and technical specifications appeared on screen. One email chain seemed to show Musk explicitly acknowledging security concerns, but directing his to proceed anyway with providing network access to a foreign telecommunications company with known government ties. Justice Barrett's expression remained neutral, but her questions to the prosecution were pointed and specific, suggesting she found the evidence persuasive. She asked detailed questions about the technical specifications of the satellites and the nature of the alleged security breaches. So your contention, Miss Montgomery, is that the defendant knowingly provided these capabilities despite direct notification that doing so violated Section 1798 of the Foreign Intelligence Protection Act? Justice Barrett asked. Precisely, Your Honor, Montgomery replied. And we have documentation showing Mr. Musk received and acknowledged that notification 3 separate times. Throughout the prosecution's 3-hour presentation, Musk remained surprisingly calm. He took occasional notes, but otherwise sat quietly, observing the proceedings with an inscrutable expression. His apparent lack of concern in the face of such damning evidence confused observers. Legal commentators broadcasting from outside the courtroom began suggesting that Musk might be planning to seek a plea arrangement. When the time came for the defense to present its opening statement, Musk rose slowly and approached the podium. He wore a simple dark suit rather than his usual casual attire, a nod to the seriousness of the proceeding. Your Honor, he began, his voice steady and clear. The prosecution has presented a compelling narrative. It's detailed, it's coherent, and it appears to be supported by substantial evidence. He paused, letting the admission hang in the air. There's just one problem. It's based on a fundamental technological misunderstanding that has led the Justice Department to catastrophically misinterpret completely legal action. Justice Barrett leaned forward slightly. That's quite a claim, Mr. Musk. I presume you have evidence to support this assertion. I do, Your Honor. But before I present that evidence, I'd like to establish some essential context about how our satellite encryption systems actually work. Context that appears to be missing from the prosecution's understanding. For the next 45 minutes, Musk delivered what amounted to a masterclass on satellite communications technology. Using clear analogies and simplified diagrams, he explained the multi-layered security architecture of his company's satellite network. He detailed how the system automatically generated distinct encryption protocols for different types of data transmission, with particular emphasis on the air-gapped security partitions that physically isolated sensitive communications from general network traffic. As he spoke, Justice Barrett asked increasingly specific questions that revealed her own substantial knowledge of technology law. Their exchange took on the quality of an advanced seminar rather than a criminal proceeding. The prosecution team looked increasingly uncomfortable as the discussion moved into technical terrain they hadn't anticipated. Then came the first major turning point. Your Honor, the prosecution has made much of these emails where I acknowledge security concerns, but direct my team to proceed anyway. May I address this specific exhibit? When Justice Barrett nodded, Musk approached the evidence screen and asked for control of the display. He zoomed out on the email chain to reveal additional context that had not been included in the prosecution's presentation. The complete exchange showed something critically different. Musk had been referring to proceeding with alternative security protocols that exceeded rather than circumvented government requirements. As you can see, Your Honor, this wasn't about ignoring security concerns, but implementing a more rigorous solution than the one initially proposed by regulatory authorities. The solution that provided greater protection while also enabling the technological innovation we were pursuing. For the first time, Justice Barrett's composed demeanor showed a crack of surprise. The prosecution team hurriedly conferred among themselves, papers shuffling as they attempted to reconcile this new information with their prepared argument. But Musk wasn't finished. He returned to the podium and addressed the court again. Your Honor, I've established that the technological understanding underlying the prosecution's case is fundamentally flawed. Now, I would like to address the legal foundation of the indictment itself. He signaled to one of his attorneys, who brought forward the 3 unmarked folders that had been sitting on the defense table. Musk handed the first one to the court clerk, who delivered it to Justice Barrett. What I'm providing you, Your Honor, is evidence that the specific section of the Foreign Intelligence Protection Act cited in my indictment was substantially amended by Congress 18 months ago in a provision of the National Defense Authorization Act. The amended version explicitly exempts commercially developed satellite networks using distributed encryption architecture, precisely the system I developed. The courtroom erupted in whispers. Justice Barrett opened the folder and examined its contents, her expression unreadable. Furthermore, Musk continued as the second folder was delivered. This folder contains documentation of the 14 separate security reviews our system underwent with the Department of Defense, all of which resulted in approval of our protocols. He paused as Justice Barrett examined this second set of documents, then delivered his final salvo as the third folder was handed to her. And finally, Your Honor, this folder contains evidence that senior Justice Department officials were fully briefed on these technical specifications and legal provisions 6 months before this indictment was pursued. They were explicitly informed by their own technical advisors that our systems complied with amended regulation, yet they proceeded with this case anyway. The courtroom fell completely silent. Justice Barrett spent several long minutes reviewing the contents of all 3 folders, occasionally looking up at Musk, then at the prosecution table, her expression growing increasingly troubled. The escalation had reached its peak. What had begun as a seemingly straightforward prosecution of a billionaire had transformed into something far more complex, potentially a case of prosecutorial overreach based on either technological misunderstanding or, more troublingly, deliberate misrepresentation. When Justice Barrett finally looked up, her expression had changed from neutral assessment to deep concern. The case had just taken a dramatic turn that no one in the courtroom had anticipated, except perhaps Elon Musk himself. Justice Barrett set down the documents from the third folder and removed her glasses, taking a moment to collect her thoughts. The courtroom remained utterly silent. Miss Montgomery, she finally said, addressing the lead prosecutor, are you and your team familiar with the amendments to Section 1798 contained in last year's National Defense Authorization? The prosecutor rose slowly to her feet. Your Honor, we are aware of those amendments, but our position is that Mr. Musk's systems do not qualify for the exemptions they provide. The technical specification. Justice Barrett held up her hand. I have some very specific questions about that interpretation. She held up several pages from the folder. The language here explicitly covers commercially developed multi-node satellite networks utilizing distributed encryption architecture with autonomous security partitioning from Mr. Musk's technical explanation and these DoD review documents that appears to describe his system precisely. Montgomery glanced at her technical advisors, who suddenly seemed very interested in their notepad. Your Honor, our technical assessment differs from. Let me be more direct. Justice Barrett interrupted, her tone sharpening. This third folder contains minutes from a Justice Department meeting where your own technical advisors informed senior officials, including 2 people sitting at your table right now, that Mr. Musk's system likely complied with the amended regulation. Yet, this prosecution proceeded anyway. Can you explain this discrepancy? The courtroom erupted in hushed conversation. Reporters rushed out to update their stories. Montgomery conferred hurriedly with her team, their expressions increasingly grim. Musk stood quietly at the defense table, his earlier confidence now tempered with a seriousness that matched the gravity of the moment. This wasn't just about his personal vindication anymore, it was about exposing a fundamental breakdown in the justice system. After several minutes of consultation, Montgomery addressed the court again. Your Honor, we request a brief recess to review these materials and confer with Justice Department leadership. Granted, Justice Barrett replied, but when we reconvene, I expect a thorough explanation of how this case proceeded despite these apparent contradictions. She turned to Musk. Mr. Musk, do you have any objection to a recess? No objection, Your Honor, Musk replied, but I would ask that all evidence presented today be preserved in the court record, as I intend to file a motion regarding prosecutorial conduct once these proceedings conclude. Justice Barrett nodded. So ordered. We'll reconvene in 2 hours. The courtroom cleared. The full impact of what had just happened began to spread through Washington and across social media. What had begun as the potential downfall of the world's richest man had transformed into a public examination of government, overreach and technological competence. When court resumed 2 hours later, the atmosphere had changed dramatically. Additional senior Justice Department officials were now present, including the Deputy Attorney General. Montgomery stood looking considerably less confident than she had that morning. Your Honor, after reviewing the materials presented by the defense and consulting with department leadership, the United States moves to dismiss all charges against Mr. Musk without prejudice. A collective gasp went through the courtroom, followed by an immediate buzz of conversation. Justice Barrett gave for silence. Before I rule on this motion, I want a clear statement for the record. On what grounds is the Justice Department seeking dismissal? The Deputy Attorney General rose. Your Honor, upon review we have determined that there are significant legal and factual issues with the case as presented that prevent us from proceeding in good faith. Specifically, we acknowledge that Mr. Musk's satellite system appears to qualify for the exemptions provided in the amended statute, and that certain exculpatory technical assessments were not properly factored into the charging decision. Justice Barrett nodded slowly. I appreciate the department's candor, belated though it may be. She turned to Musk. Do you have any response to this motion? Musk stood. Your Honor, while I don't oppose dismissal, I do believe this case raises serious questions about how technical evidence is evaluated in national security prosecution and about the responsibilities of prosecutors when presented with exculpatory technical assessment. These are issues that affect not just my case, but potentially many others. Justice Barrett nodded thoughtfully. I share those concerns, Mr. Musk. She looked back at the prosecution table. Motion to dismiss is granted. However, she continued, her voice taking on a sleek quality, I am ordering a comprehensive review of the decision-making process that led to the indictment be conducted by the Office of Professional Responsibility and submitted to this court within 90 days. She looked around the courtroom, meeting the eyes of the prosecutors, Musk, the press and the public observers in turn. What we witnessed today transcends the fate of any single defendant, no matter how prominent. It speaks to fundamental questions about technical literacy, our justice system, and the proper balance between national security concerns and technological innovation. These are issues that indeed demand thorough examination. With a final strike of her gavel, Justice Barrett closed the proceeding. This case is dismissed. Court is adjourned. As the courtroom began to empty, cameras captured a brief, unguarded moment. Justice Barrett looked directly at Musk and gave an almost imperceptible nod, not of deference or apology, but of professional respect for a legal and technical presentation that had exposed critical flaws in the system she was sworn to uphold. For his part, Musk's typically expressive face remained measured and serious. This hadn't been a victory to celebrate, but a systemic failure to address. As he gathered his documents, the usually outspoken billionaire offered reporters only a brief statement. Today's outcome isn't about me. It's about ensuring our legal system keeps pace with technological innovation. Justice requires both legal expertise and technical understanding, especially in cases where national security and technological advancement intersect. The triumph wasn't that Musk had defeated the system, it was that he had exposed its flaws in a way that might ultimately strengthen it. Within hours of the dismissal, Musk's Barrett and Justice Tech were trending globally. The case had touched a nerve, raising profound questions about the intersection of law, technology, and governmental power in the digital age. Justice Barrett, known for her judicial restraint and privacy, took the unprecedented step of issuing a public statement the following day. Yesterday's proceedings in United States versus Musk highlighted critical gaps in how our legal system addresses complex technological matters. As technologies advance exponentially, our legal frameworks and those who enforce them must evolve accordingly. I have initiated discussions with the Judicial Conference about enhancing technical training for federal judges and establishing improved protocols for evaluating technical evidence in cases with national security implications. The Justice Department moved quickly to contain the fallout. The Attorney General announced the formation of a special technology competence task force to review how technical evidence was gathered, analyzed, and presented in federal prosecution. 3 senior officials involved in the case against Musk submitted their resignations within the week. Congressional hearings were announced with both Democrats and Republicans expressing concerns about the case. Senator Elizabeth Warren pointed to it as evidence of the need for greater technical expertise within regulatory agencies, while Senator Ted Cruz characterized it as a cautionary tale about government overreach in the technology sector. For Musk, the aftermath brought both vindication and new challenge. His company's stock prices soared upon news of the dismissal, adding billions to his net worth overnight. Yet, rather than taking a victory lap, he channeled the momentum to action. 2 weeks after the dismissal, he announced the creation of the Technology Justice Initiative, a nonprofit organization dedicating technical literacy in the legal system. What happened in my case happens to people without my resources every day, Musk explained at the initiative's launch. When prosecutors and judges lack technical understanding, justice suffered. Our goal is to bridge that knowledge gap through education, advisory services, and policy reform. The initiative immediately attracted support from across the political spectrum and throughout the tech industry. Even companies that had historically been Musk's competitors pledged resources and expertise. Perhaps most surprising, 3 months after the dismissal, Musk received an unexpected invitation. Justice Barrett requested his input on a judicial training program on emerging technology was developing the Federal Judicial Center. Their collaboration, a conservative Supreme Court justice, politically unpredictable tech billion, used many political observers. But those who understood the deeper implication of the case recognized that their shared concern transcended conventional political boundaries. In a world where technology was increasingly central to nearly every legal question, the integrity of the justice system depended on closing the knowledge gap between those who created technology and those who regulated it. A year after the case's dismissal, its impact continued to reverberate through the American legal system. The Justice Department had overhauled its technical review procedures for all technology-related prosecution. Congress had passed the Technological Evidence Standards Act, establishing new requirements for technical expertise in cases involving advanced technology. Law schools across the country had expanded their technology law offerings, with several creating dedicated centers for technology and judicial education. At the 1-year mark, Musk and Justice Barrett made a rare joint appearance at a judicial technology conference. Though they still disagreed on many legal and political issues, they had found common ground on a crucial principle that justice in the 21st century required a legal system as fluent in technology as it was in law. The case that brought us together could have resulted in my imprisonment, Musk noted during their panel discussion. Instead, it became a catalyst for necessary reform. That transformation from potential injustice to systemic improvement represents the legal system at its best, self-correcting when confronted with its own limitation. Justice Barrett nodded in agreement. The strength of our system isn't that it's perfect, it's that it can acknowledge imperfection and adapt. The technical knowledge gap exposed in Mr. Musk's case existed long before that specific prosecution. The difference was that this case made that gap impossible to ignore any longer. As their discussion concluded, a law student asked what they considered the most important lesson from the case. Justice Barrett responded first, that justice requires humility, the willingness to recognize when we need expertise beyond our own. Musk nodded and added, and that systems only improve when their flaws are exposed by those with both the knowledge to identify them and the courage to challenge. The case that had begun as a high-stakes legal battle between a powerful justice and a wealthy innovator had evolved into something far more significant. A turning point in how American law approached the technological challenges of a rapidly changing world. For observers around the globe, the lesson was clear in the high-stakes intersection of law, technology, and power. True brilliance wasn't about winning at all costs, but about transforming conflict into progress. If you've enjoyed this analysis of how legal brilliance and technological expertise can transform our justice system, don't forget to like and subscribe for more stories that explore the fascinating intersections of law, technology, and power. Share your thoughts in the comments about other cases where technical understanding or lack thereof has impacted legal outcome. The future of justice depends on bridging these knowledge gaps, one case at a